interview that Kyle Rittenhouse gave to the reporter from the Daily Caller. Does it help him, in your opinion, or does it hurt him?
Angela, I think it cuts both ways. I mean, from the defense perspective, he's there saying that he's, protecting property. He is, a medic. Obviously, he's not a trained EMT, but that's something that he said. So, he appears peaceful. He appears kind of cooperative. I mean, what I don't like from the defense perspective, and what I do like from the prosecution perspective, is he's there with his AR-15, with a scope and a strap, and he's bringing this to a protest or a riot, depending on whatever side you're on. So I think that's something that's helpful for the prosecution because, again, that's not a firearm that's typically used by a lot of folks. And it's really something that's associated with, mass shootings, school shootings, movie shootings. So there's a reason that in opening statement, the prosecutor kept harping on the fact that it was an AR-15 and that Rittenhouse was the only one of the hundreds of people that killed anyone that evening. So I think it's something that does cut both ways, and that's why both sides are using it in argument.
This reporter who's on the scene, who's watching all of this unfold, basically says it appeared that Rosenbaum, one of the victims, was actually reaching for the barrel of the gun.
This is critical evidence for the defense and very, very helpful to Rittenhouse's self-defense argument. I mean, there's 3 victims here, but everyone is focused on Rosenbaum because that is the weaker self-defense argument. He's armed with a plastic flag, unlike the other victims, one of which had a skateboard and was using it at least to assault Rittenhouse, allegedly. The other had a handgun. Rosenbaum had nothing but a plastic bag. And the prosecution is arguing that Rittenhouse was chasing Rosenbaum. And the defense is saying, no, no, no. It was actually Rosenbaum who was chasing Rittenhouse and trying to get his firearm from him. And that's why he was shot. So when you have an independent witness like this, a reporter who is supporting that defense argument, that's incredibly helpful for the defense's self-defense argument in this case.
So, Neama, I'll start with you. Should this information, they're calling it minute THC levels, should it be kept out of the trial? Should the jury not hear about this?
I think it should be kept out, Anjanette, and this is why. It's a small amount, and there's really no evidence that marijuana leads to any type of violent conduct. Obviously, this is a self-defense case. The McMichaels and Roddy Bryan are arguing that Ahmaud Arbery tried to grab the shotgun, and that's why Travis shot him. So, small amount of marijuana, not really relevant to that issue. And again, there's no evidence that it leads to any type of violence. Obviously, I understand what the defense is trying to do here. They want to dirty up the victim as much as they possibly can. And bringing up drug use, even if it's marijuana, is something that's potentially helpful for their case. So they're going to try to get it in. But I expect the judge to keep it out. Not really relevant in this particular case, in my opinion.
This is interesting because, when I think of people using marijuana, I do think of people being pretty mellow and pretty relaxed. But this gentleman, Jason Sheffield, is saying, no, not so much. You can be aggressive.
Yeah, so obviously Lisa and I here in Southern California, marijuana use is pretty common. It's illegal here under state law, but it's very different in other parts of the country. It's still a Schedule I drug under federal law. It's not legal in a lot of states, and a lot of folks have very strong feelings about marijuana use, against marijuana use. So I understand what the defense is trying to do here to say that, look, this is someone who uses drugs, even though there are folks that don't believe really marijuana is a drug, certainly not like other hard drugs. But again, there are potential jurors out there that will not like this marijuana use. And that's why the defense wants to try to bring it in this particular case.
There was some testimony from Ryan Balch, who said that Kyle Rittenhouse claimed to be 19 and to be a medic. So Kyle Rittenhouse was not 19. He was 17 at the time. How big of a deal is that, do you think? How big of a deal do you think it will be for the jury that Kyle Rittenhouse, accused of murder, was lying about, who he was that evening?
Angela, it's important. It's not critical, but it's certainly helpful for the prosecution to show that this is someone who's 19, who bought a gun using a straw purchase through his friend Dominic Black. Shouldn't have had that AR-15. Lied about being a medic and having medical training. And importantly, one thing that this witness said is that he didn't think he was qualified to be there doing what he was doing, and particularly defending people and property, because he was so young and really didn't have any experience, really no law enforcement experience, no military experience, not someone that should have been there in Kenosha that night. So a couple good nuggets for the prosecution with this particular witness.
What do you think it's offering that's helpful to the state?
Well, I understand why the state put him on. The last thing you want is a witness like this coming on during the defense case. So what you do is, if you think it's a potentially bad witness, you bring it on during your case as a prosecutor. You sandwich him or her between other witnesses. You don't want to start with a witness like this, or certainly not end with a witness like this. So, I mean, he is giving some statements that are helpful to the defense, showing that Rosenbaum is an aggressor that said, I, expletive, am going to kill you. Certainly not helpful. But there's also some good nuggets for the state. Initially, that plastic bag that we've been talking about so much. We'll try to say that it was potentially filled with chemicals. And again, this is speculation, but ultimately what the prosecutor was able to do was to pin him down and say, well, no, there was nothing in there that was harmful. Maybe it was soap, maybe it was plastic bottles. But when after he was killed, Bolch looked at it, there was nothing in there that could be consistent with lighter fluid, Molotov cocktail, explosive, anything of that sort, which again was helpful for the state.
So, Neama, I'm going to bring you back in. Neama Rahmani is a former federal prosecutor. What do you see as the point in the prosecution introducing that video?
I think they have to introduce the video because you know what's going to come into the case. The defense is going to bring it in to show that Rittenhouse was there trying to help people. He's, arguably putting himself at risk, asking if folks need medical attention. Clearly, he's not certified and probably not qualified to provide that medical attention, but he's there to help, and that he is at least arguably not looking to get into a violent situation. So obviously, that's going to be the defense argument. The prosecution wants to get this video out in their case in chief because it's something that the defense is going to argue. So might as well take the sting out of it and put it on your case.
After, I believe, about 5 hours of deliberation, the insanity defense obviously didn't work. Probably not a big surprise to you.
Not at all. The only surprise, Anjanette, is that it took this jury 5 hours to reach a verdict. I mean, this is someone that should have been convicted in a matter of minutes. I mean, obviously, he'd already been convicted of killing his pregnant ex-girlfriend, was spared the death penalty in that case. Now, obviously, he killed a police officer, and the only question now is Markeith Loyd going to get the death penalty in this case, the subsequent case? And probably the only other surprise was that there was no outburst by him when the verdict was read. I was kind of expecting that as well.
Or the death penalty will start on Saturday. And Neama, if you're on this case, you're in front of the jury presenting this case, I mean, what kind of mitigating evidence do you think that the defense could present that would result in a life sentence rather than the death penalty? I mean, Lieutenant Clayton, the prosecution said, was trying to take him into custody on a murder charge, and they basically said he executed her.
He did. I mean, her body was on the ground and he continued shooting. I mean, this wasn't someone who just shot to get away. I mean, this was really sort of terrible conduct while he was on the run from another case, another terrible case. So this is an individual, and obviously there's arguments for and against the death penalty, public policy reasons. But if you believe in the death penalty, Anjanette, this is a death penalty case. The only sort of argument I could see is clearly this is someone, Markeith Loyd, that has serious mental health issues. Obviously, he was found competent to stand trial. The insanity defense didn't work at all, but that's something I'm sure his defense attorneys are going to present as potential mitigation evidence during the penalty phase.